Welcome to Getting Facts in the Administrative Record in Collection Due Process, sponsored by the ABA section of Taxation. If you are seeking CLE credit, you must attend the entire program. Partial credit is not available. Please do click on all participation verification alerts during the program to confirm your attendance. Immediately after the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested. Once the completed form is submitted and your attendance verified, your certificate will be emailed to you. I would like now to turn the program over to today's moderator, Matthew T. James. Matthew?
Thank you. I am Matthew James. I'm the director of the Temple University Beasley School of Law Low Income Taxpayer Clinic, and I'd like to briefly introduce my fellow panelists. First, the Honorable Judge David Gustafson, who was appointed to the United States Tax Court by President George W. Bush in 2008. After graduating from Duke Law School in 1981 and working for 2 years in a tax group at a Washington, D.C. firm, he spent 24 years in the tax division of the Department of Justice, conducting and then supervising litigation of tax cases in the United States Court of Federal Claims. Next, we have Elizabeth Morges. She is a senior attorney in the Baltimore office of the Small Business Self-Employed Division of the IRS Office of Chief Counsel. She has more than 10 years of experience litigating a wide variety of tax issues. Before transferring to the field, she worked in the national office in Washington, D.C. Elizabeth earned an LLM in taxation from Georgetown University Law Center and attended the University of Baltimore School of Law, where she took tax practice and procedure from our next panelist, Professor Jack Snyder. Jack graduated from Duke Law School in 2000 and served for 5.5 years at the Department of Justice Tax Division, handling civil tax litigation of all types in district court. In 2006, he joined the faculty at the University of Baltimore, where he has taught in the graduate tax program and directs the Low Income Taxpayer Clinic. A quick disclaimer: any views expressed in the presentation reflect the unofficial individual views of the individual speakers and do not necessarily represent the policies of the United States Tax Court, the Internal Revenue Service, or any other organization. So our objectives today are to talk about the record rule and be able to define it and the scope and standards of review that are applicable. We will explain how to build the administrative record and then how to identify perceived deficiencies in that record. Jack, can you tell us about the record rule?
Thank you, Matthew. The record rule, which is really what we're talking about globally today, is a principle that exists in CDP, but also in many other areas, such as the Administrative Procedure Act and even appeal from a lower court to courts of appeal. As a general principle, the record rule limits what facts a court can consider when reviewing the final decision of an agency. Here we're talking about the administrative decision of the IRS in a collection due process hearing. And just like Court of Appeals reviewing a trial-level court's decision, the court reviewing the agency normally cannot find new facts. Its decision instead is based on the record that was developed at the agency level. If there's a problem with the record, the remedy isn't for the reviewing court to substitute its judgment normally. The usual remedy is to remand to the agency for additional fact-finding. And these principles that I just explained go beyond collection due process. Record rule is really something fundamental to courts reviewing agencies. And much of what we'll be talking about today is how the record rule applies specifically in CDP in some ways differently from the way it otherwise does. So,
this is Judge Gustafson.
Go ahead.
Pardon me, did I just talk over Jack? The APA is the law that governs so much of people's interactions with and disputes with the federal agencies, and from some perspectives, it's the template, it's the boilerplate, it's the universal rule, but it's relatively new to tax court jurisprudence. The reflexive answer in the tax court sphere to the question, does the APA apply, is no, because since so much of the tax court's litigation is its traditional deficiency cases, and since the law is clear that the APA does not apply to the review of to the court's decision in deficiency cases, the tax court has been in the habit of not tuning into the APA. But the several recent forms of jurisdiction that have been given to the tax court have begun to make it somewhat more common for the tax court to actually be plugged into that jurisprudence. The whistleblower cases of being a significant instance, new passport cases, all have us consulting the APA. And in the CDP era, the collection due process era, when that jurisprudence was introduced to the tax court, it acquired jurisdiction over those cases, it began to be harder to say that the APA didn't apply or couldn't apply within the tax court. So you'll see that in the earlier cases in the tax court, even where the question wasn't put directly, does the APA apply, the tax court referred to the APA and said that it consulted APA-like principles in deciding some of these standard and scope of review questions. And so now we find that the tax court is beginning to be, beginning over the last decade maybe, to be more comfortable in applying and commenting on the APA in these contexts. When we are invoking those principles, APA principles, literally or in type, we're reviewing an agency decision based on the whole record or those parts of it cited by a party. So when we are deciding according to the APA, we're looking at that record that was developed before the agency, and that record includes the information about the case that was considered, and well, the court will look at that record and look at the decision of the agency to assure that the agency considered what it was supposed to consider, and to see the information that it consulted to decide that. And the court, in making that review, will not, where the APA applies, will not look outside that record. It will confine itself to the record. And if, in making that record-bound review, the court finds that the agency's explanation or discussion was inadequate, then the general remedy is to remand the case back to the agency for further findings. That is not to inquire on its own as the court into the merits itself and to decide those things itself in the first instance. The court is, after all, reviewing a decision, not making a decision. And the theory of the APA is that the agency, the executive agency that is deciding the case, is the body that Congress has charged with administering that law, and it is the body that should have the subject matter expertise relevant to that law. So the court defers in that sense to the agency and puts back in the agency the principal responsibility of deciding these questions in the first instance, rather than the court taking on the job of being the decider in the first instance. I think I'm handing it off to Matthew now.
So a couple of the terms that Judge Gustafson was just speaking about are the scope of review and the standard of review. So the scope of review, this is the set of information that the court can consider when it's reviewing that agency's action. So here, the IRS. We have the administrative record, which is what we just spoke about. We'll talk about a little bit more. And then we have the ability to introduce new evidence. The standard of review is the degree of scrutiny that the court is going to give that agency's decision. So when we're looking at the standards, we have the abuse of discretion standard and a de novo review standard. In an abuse of discretion, the tax court is typically going to uphold the appeals determination unless it determines that that determination was arbitrary, capricious, or without sound basis in fact or law. What they're also looking for is whether the administrative record is adequate enough to include clear findings that the appeals officer or clear findings by the appeals officer on relevant issues that the court can make a determination whether the record supports the findings of that appeals officer. So for example, if the court is reviewing the underlying liability, it will typically use the de novo review. If there is also other issues involved in that case, they'll use the abuse of discretion standard. If the underlying liability is not at issue, then the tax court is going to review the entire determination just for that abuse of discretion. Judge Gustafson, did you want to give any practical examples of how this looks?
Catch me flat-footed. I want to, at this point, I guess all I want to say is that the distinction, how this looks, depends in theory on something that we're going to discuss in just a moment, which is what circuit might an appeal in this case go to. Three of the courts of appeals have decided that in CDP cases we are confined to the record, the administrative record, and can't go beyond it, can't receive into evidence at trial anything that was not put into the record before the agency, the appeals office. That's in three circuits. In the other circuits, it remains the view of the tax court that we can hear additional evidence. So in those other circuits, the theoretical answer to these questions is different than in the circuits that have a record rule, where we're not bound to the administrative record and can have a trial and receive additional evidence. Any liability questions will look like good old-fashioned deficiency case litigation where we're deciding the matter based on the evidence put before us. And that's a minority of CDP cases that have a liability question in them, but there are some, and where we do, those cases will look just like the ones that we're accustomed to in the deficiency context. In the record rule cases where we are confined to the record because of the circuit that we're appealable to, then the cases really happen without a trial. There would be a very rare circumstance in which we would have a hearing or a trial in order to decide anything about the case beyond the contents of the record. Someone might conceivably challenge the adequacy of the record, and we might have a hearing about it. But apart from that circumstance, the case is really going to be a paper case that's decided on the basis of the administrative record. We'll decide the cases that are before us for abuse of discretion, which will be typically all the collection-related cases, whether an installment offer should be accepted, whether an offer in compromise was properly evaluated. In all those circumstances, we evaluate for abuse of discretion on the basis of the record, and we don't substitute our judgment for that of the appeals office. So it's a very a standard that is very forgiving, very generous to the appeals office. Where we are in that record rule context, deciding a liability question, we're reviewing it de novo, but we're deciding it on the basis of the record before us. So we don't defer in the same way to the judgment of the appeals office, but we do confine ourselves to the evidence that was before the appeals office.
And this seems like a good place for me to jump in and just share the IRS perspective on Robinette. I just wanted to point out that the IRS disagrees with the tax court's opinion in Robinette. So the IRS's position is that review should always be limited to the administrative records, and we're going to make that argument in every CDP trial. So we'll always preserve our objection to any evidence that's outside the administrative record.
What you're seeing now in the slides is a summary of what Judge Gustafson and Elizabeth just alluded to. This is a general summary of the record rule in collection due process cases. If you look at the statute itself, it presumes the existence of some record, but the scope of that record is not defined there, and therefore it's been left to the tax court and the courts of appeals to make that determination. The cases listed there are generally grouped under the name of that second case, Robinette, which is the best known one, which went against the tax court's own view. The tax court's view is generally that new evidence may be considered in an appeal to tax court. That doesn't necessarily mean that it will change the outcome for all the reasons that Judge Gustafson alluded to, but it is available. In certain circuits, pre-listed here, review of CDP by the tax court is going to be limited to the record developed at the administrative level. I actually have a question for Judge Gustafson based on this. How often does the court actually see, even in relatively open record jurisdictions, not limited record jurisdictions, how often does the court see attempts at new evidence being introduced?
I don't have a good data-based answer for you, but just an impression and an anecdotal answer. But I'm pretty confident about it. I think that the incidents are few. Even in as you say, even in the cases where theoretically the taxpayer could produce information, in most instances the taxpayer had an opportunity to submit whatever information it wanted to submit before appeals, and the fact that it didn't submit something there probably means that they didn't have it. Not always, but normally people gave their best shot at appeals, even if their best shot was, not sophisticated from a litigation point of view. It was their best shot, and so we don't often see it. So most of the cases, most of the CDP cases, even in non-record rule, even the ones that would be appealable to non-record rule courts of appeals, most of those cases are decided by motions for summary judgment, that is decided in the absence of any genuine dispute of material fact. So the cases are few. It could be that and probably is true, that the presence or absence of counsel during the appeals office process could affect this. If counsel enters the lawsuit, who in a circumstance where there was no counsel before the Office of Appeals, that might be a circumstance where one could expect to see new evidence presented. But that may end up actually then being a circumstance in which there's an attempt to remand the case to appeals for further consideration with the help of counsel and any evidence they might have been able to generate and obtain. And for all I know, Chief Counsel of the IRS consents to that to some substantial amount. So I think that the incidents when new evidence is offered are relatively few.
Thank you, Judge Gustafson. We'll talk about remand a little bit later, but I thought it was important that we mention that issue now, because I think it's important for this audience to see that regardless of whether you're in a relatively open record circuit or a strict record rule circuit, that really it's built, even though we're talking about litigation in one sense today, it's really building the administrative record and figuring out what it contains at the appeals stage before going on the appeal to the tax court that really matters so much, and I think Elizabeth is going to tell us a little about the contents, the base contents at least, of what is in the administrative record. That is, what are we talking about building for the rest of this discussion?
This is Judge Gustafson.
Yes,
could I interrupt? Could I interrupt just a moment and say, maybe this is an elaboration a bit of my answer before. I spoke about the dichotomy of the record rule jurisdictions and the non-record rule jurisdictions, and so noted that one might get evidence in a non-record rule jurisdiction. But remember that there's the general principle applicable in all jurisdictions, all appellate jurisdictions, that a taxpayer can't be relying before the court on arguments or issues that it failed to present before appeals. And if you look at the Murphy case that is cited on the previous slide, if you look at the tax court's opinion in Murphy before it was appealed to the First Circuit and the First Circuit announced a record rule, you'll see that even in its Robinette thinking, the tax court in Murphy articulated the standards that might limit a taxpayer from introducing new evidence in the tax court, not because there's a record rule, but because you can't withhold things from appeals and then bring them up for the first time in the tax court. There's sort of an exhaustion of remedies principle that's operative there that requires, even in a non-record rule jurisdiction, that the taxpayer be forthcoming and give appeals the information that appeals would have needed in order to decide a matter that the taxpayer put before appeals.
Thanks, Judge Gustafson. And just to go back to what you were talking about earlier, I just wanted to say that anecdotally, I was trying to think of how many CDP cases I've had, and I don't know, I would guess 100. I really don't know. But I have mostly always either filed a motion for summary judgment or worked with the petitioner to get it settled some other way. And I have had one CDP trial that was de novo for review for underlying liability. And again, just like you said, Judge Gustafson, it was just like any other deficiency trial. And I've seen 3 CDP trials in my time in counsel that were in Baltimore that dealt with just CDP cases that were not de novo review, that did not involve the underlying deficiency, the underlying liability. So just anecdotally, that's about how rare I would say it is. And in those cases I saw, we did make the argument that we think that it should be limited to the administrative record, but we're obviously not in one of those jurisdictions. But anyway, going on to the administrative record. The administrative record includes everything from the CDP notice and the letter 12153 requesting the CDP hearing, all the way through the notice of determination. So it includes everything in between that as well. It should include every single thing that the appeals officer considered in making their final determination. So as an attorney for the IRS Office of Chief Counsel, when I get a CDP case for litigation, I'll get a big folder. We call it the admin file, so the administrative record basically. And so what's in there is supposed to be every single thing that the appeals officer considered. When I prepare a motion for summary judgment in one of these CDP cases, I need to attach the entire administrative file. Usually what I do is I prepare all the documents as separate exhibits and I'll order them chronologically. Almost all CDP cases have the same basic documents. So I'll start with the CDP notice, then the CDP request, and then I'll put in the account transcripts for the year it issues. And usually Next is the case activity report, which is a document where the appeals officer writes down everything that happens in the case and everything they did and everything they said and everything the taxpayer said, at least in their summary. So that case activity report, which will say case activity record print at the top, will include, like I said, it will include descriptions of the conversations between the petitioner and the appeals officer during any phone calls or meetings that they have. And in that administrative file, there will also be letters, both letters from appeals and from the taxpayer to appeals, and any other documents that the taxpayer sent in to the appeals officer. We can go to the next slide here.
Elizabeth, how large have you seen these administrative record files?
It really depends. If there was an offer in compromise at issue, then it's going to be a lot bigger. But sometimes I'll get a box, or sometimes it'll be a few inches thick, and sometimes it'll be very, very thin. So it really just depends. I get a lot of these cases where the taxpayer was not very responsive to the appeals officer, and it might just be a few documents in there.
Jack, would you like to explain on building the administrative record?
Yes, thank you. So if we look at the list that Lizzie was just discussing for a minute here and think back to that discussion, nearly all of these items are either created by or received by the agency, the IRS. And in that sense, the record is created by the service. What that means as a taxpayer's representative is that everything needs to be placed in the agency's hands, regardless of the weight the agency is giving to it. If imagine that we have a collection due process case involving an effective tax administration offer in compromise, kind of offer in compromise that is often challenging to service personnel. And the service personnel essentially decline to consider the evidence of economic hardship, which does sometimes happen in real cases I've seen. In a situation like that, the representative should still furnish that supporting evidence to the appeals officer, because if it's not furnished to the appeals officer, the tax court will never see it. It'll be in a strict record rule jurisdiction, it'll simply be excluded. And there's a good argument that, as Judge Gustafson was explaining earlier, it's been sandbagged even in a more open record rule situation. So really, one of the fundamental pieces of representing a taxpayer in a collection due process hearing is second only to resolving the collection issue, is building the administrative record. Notice, in addition to the fact that everything on that prior list was created or received by the service, is notice that there were no oral items. The only way an oral communication is going to make it into the administrative record is if the service employee makes a note of it. The settlement officer or appeals officer makes a note of it in case history. Therefore, it's critical to, as I love to say, document, document, document everything. Everything must be written down and sent to the service in a writing to ensure that it reaches the review stage. If that is done, in many ways, despite the fact that the service creates the record, the taxpayer is really master of the record. As I said, the taxpayer, for purposes of a CDP appeal, doesn't need to worry about the Office of Appeals take on the evidence that's furnished. It just needs to ensure that that evidence is put before appeals so that that evidence gets considered. One important thing to note here, and we have a quotation from an important Treasury reg here, is that collection due process hearings are very informal. Those on this call who have dealt with a lot of them know that the term hearing is used here very loosely. In modern collection due process hearings, the hearing, in air quotes, is usually a series of exchanges of letters and a series of exchanges of phone calls. There's no hard and fast point where it clearly begins, and it's very difficult often to tell when it clearly ends. That is one way in which taxpayers are challenged here, particularly, as Judge Gustafson was saying, unrepresented taxpayers. The hearing is very amorphous. One thing to keep in mind is, as I said, that taxpayers are masters of the record. Taxpayer doesn't need to worry about the service's take on information. The taxpayer merely needs to ensure that that the evidence gets before the service. Matthew, I think you're taking us on to our next topic.
Well, Judge Gustafson, did you want to talk about oral comments and some analogous situations with the TEG?
Sure. The reg that's quoted there for you on the slide says formal procedures do not apply. And that's true. The reg says it, so that makes it true. The slide also notes that no transcript is required. In fact, no transcript is made. If you read the regulation on this point, that's in a Q&A form, you have the sense that the author seemed to be trying to reassure the self-represented nervous taxpayer that he doesn't need to fear the proceeding. People are often nervous. I'm often nervous about stepping into circumstances that I don't know about. And when people think they're entering into some legal hearing, that might make them nervous. So the reg assures them that isn't true. This is informal. The reg tells you you don't have to call witnesses. In fact, you're not allowed to call witnesses. So although the reg's heart is in the right place, so to speak, there's actually the risk that people are lulled into inactivity by this informality. Once it gets before the court, it may feel very formal, and one may look at the record that was casually developed before appeals as being inadequate, and if only I'd known what I really needed, I would have done it here. If you contrast this with what I think of as exempt org practice, you'll maybe understand the contrast I'm seeing. Many years ago, I was involved in some cases where applications for tax-exempt status, for recognition of tax-exempt status, were filed with the IRS on maybe it's Form 1023. And if your application is denied, then you can file a protest and you can get a hearing before appeals. And in that context, the rules are quite clear that, yes, you can have your oral hearing before appeals, but anything that you say that's important, anything that you want to count, you need afterwards to reduce to writing and sign and submit under penalty of perjury. That sort of a rule assures that a record is developed that includes everything that the applicant might wish to submit. Now, I don't suppose that sort of a rule or procedure would be necessary or even appropriate for the CDP context, but if you compare them, you'll see that there's a very strong possibility that the taxpayer in the CDP context will fail to put things into the record. He will assume that he was heard and that the things he said are being taken account of. And he may even see some of those comments reflected in the case record that is Morges referred to, that the appeals officer keeps, the written record. But if you've looked at a few of those records, you will see that, not surprisingly, they are economical in their expression. They employ word processing, and there's nothing wrong with using word processing. I use it in my opinions. I hope there's nothing wrong with it. But one does not always feel that one seldom feels that the written comments by the appeals officer in this case activity record are anything like an attempt to record everything that was said. I'm sometimes impressed by the amount of information that they are able to put into there. But just consider one very significant fact that may or may not be present there is that the taxpayer is supposed to be, who is attempting to raise a liability issue in the CDP hearing, is supposed to be asked whether he received a notice of deficiency. And that's an important fact. If you received a notice of deficiency and didn't file a deficiency case, then you lost your opportunity you forfeited your opportunity to challenge liability, and it won't be entertained by appeals or by the tax court in your CDP case. So that's an important question. If the taxpayer didn't receive the notice of deficiency and wants to challenge liability, then the taxpayer certainly wants that fact of non-receipt to appear in the record, and he might say to the appeals officer that he didn't receive it, but if he's relying on the appeals officer to note it in the notes, then he's sort of doing so at his peril. And I'm presuming good faith on the part of the appeals officer, but I'm also assuming humanity and fallibility on the part of the appeals officer, just as I would on the part of the judge. And so the taxpayer would be much better advised to reduce to writing his assertion, his claim, and maybe to elaborate on it a bit. The bald statement that I didn't receive it may look pretty bald when it's being reviewed if that mere assertion appears in the case activity record of the appeals officer. So I picked that out as an example where the taxpayer could serve his case well by writing, by repeating in writing what he contends about his non-receipt of the notice of deficiency and sending it to appeals with any other documentation that he's been invited to submit. Likewise, the informality of the proceeding includes that the taxpayer can't call a witness. That's not as bad of a disability in a tax case as it might be in some cases. The tax case is always about the transactions and experiences of the taxpayer. So quite often a taxpayer is able himself to state from personal knowledge his entire case. But sometimes that's not so. Sometimes, especially if there's not going to be a trial, but instead a mere review of the administrative record, the taxpayer would be well advised to get a statement from another witness. I'm thinking, for example, of a case involving a dispute about earned income credit relating to a child. Maybe you have somehow in a CDP case an issue coming up about whether the child really shared an abode with the taxpayer. When we see trials on those questions, we see taxpayers calling neighbors to say that, yes, that child lived with him, or maybe calling someone from a school or some other relative to confirm the testimony of the taxpayer that the child resided with the taxpayer. Well, if in the CDP context, there will be no witness called. And in that sort of a circumstance, perhaps the taxpayer would want to get a written statement of the prospective witness, the neighbor, the school official, the doctor. Of course, that wouldn't necessarily. I mean, I'm thinking of a submission by a pro se taxpayer. I don't suppose they'd have the thought of getting a statement notarized, having an affidavit. But even the mere letter of the additional witness would be better than nothing, and would show that the taxpayer is ready to bring in other people to confirm what he's saying. I think it would likely affect the services treatment of the matter, and it would likely influence the court. So again, I'm talking on the general subject of the informality of the record and the ways that can disadvantage the taxpayer if they ought to be more aggressive in making the record that they want in the manner that Mr. Snyder was commending.
I will say this discussion of the word informal, it just reminded me of a time where it wasn't a CDP case, but I had a petitioner come in and I said, I'm going to interview, it's informal, whatever. And so we're sitting in there and there's 3 attorneys and we're wearing our suits and he's in there and I start asking him questions and he says, wait, I thought this was informal. And so I think it is interesting that as lawyers, we have a different definition in our minds of informal versus formal. So it can be confusing to petitioners, taxpayers, especially pro se taxpayers. So I think it is an important point to raise. But what I do want to mention is that taxpayers and their representatives actually really do have power over the information and documents getting into the administrative record than they realize. So as representatives, you should send in everything that you want the appeals officer to consider. And you can send in additional documents or explanations other than only what the appeals officer requests. And again, I just want to reiterate what Jack was saying before, just a reminder that the CDP hearing is more than just one phone call or just one meeting. It's everything between the CDP request and the notice of determination. There's so much confusion over this, especially by pro se petitioners, that they think they're hearing, I had my hearing, it was when I called and we spoke. And they might not even realize that they can send in more items, and that's still part of the hearing. And Jack, do you have any advice for practitioners about submitting documents for the administrative record?
I do have a couple of points. First of all, just nodding in passing to an issue that's not often considered in most CDP disputes, that the statute requires that the service verify that the requirements of any applicable law or administrative procedure have been met. If there's any possibility of a problem there, those issues should be raised at the appeals level, and certainly, of course, at the petition level. Perhaps more importantly, the thing I really want to emphasize here is we've talked a lot about what the administrative record is and getting things into it. And as Ms. Morges was just saying, even though the service is the organizer and the gatherer of the record, in many ways the taxpayer is the master of the record. However, there's another trap for the unwary here, particularly for unrepresented taxpayers. The administrative record does not contain all correspondence, all interactions between the taxpayer and the service. It contains all correspondence, or should contain all correspondence, all interaction between the taxpayer and the Office of Appeals. There's a distinction there. Administrative hearings not held before appeals, amorphous administrative hearings or otherwise, even ones related to the same notice of intent to levy or notice of federal tax lien filing that triggered the collection due process rights, those are not part of the record by default. For example, on the slide here, you see a citation to the Loveland case. In that case, the taxpayer proposing as the collection alternative in the collection due process proceeding an offer in compromise. The offer in compromise had been submitted to the centralized offer in compromise unit and was considered there. But the OIC and its supporting documents were never submitted to the appeals officer. They were only submitted to the line division of the service. Because those documents had never made their way to the Office of Appeals, they never made their way into the administrative record for purposes of the collection due process hearing. And it's a situation like that where the lack of the information being there can be decisive when the matter is appealed to the U.S. Tax Court. So it's critical that not only that everything be sent to the service, but that everything be sent to that particular point of contact at the service. It's useful for a taxpayer to think of the settlement officer or appeals officer as the record assembler, the record creator, and to ensure that anything previously sent to a line division, that especially if it's part of that collection alternative being proposed in the CDP hearing, that it make its way into that person's hands.
This is Judge Gustafson. If I might just chime in here, Mr. Snyder is alluding to something that I see crop up in a variety of contexts, and that is taxpayer confusion or uncertainty about who it is that he's dealing with. To the taxpayer, the tax system is sort of a monolith, and I think taxpayers have to be forgiven for viewing it that way and thinking that when they sent something in, why it's in. But in fact, the tax system couldn't work if the responsibility were so diffuse. So we do say that a CDP petitioner has to have dealt previously with appeals. But the person representing the taxpayer in a tax court case, maybe I had the clinician in mind, taking on a case that you didn't develop and with a client that you didn't know before, and now trying to work that case. Be aware that client may well have misunderstandings about just what he has submitted, good faith misunderstandings. It is very common for me, the judge in the tax court suit, to hear a petitioner say to me, "Oh, I gave you guys such and such stuff earlier." I have to point out to them that I'm not the IRS and that neither is the IRS lawyer in the courtroom the IRS for all purposes, but is he trying to say that he gave it to exam? The distinctions are not intuitive to the taxpayer. And so someone handling a CDP case may bump into that reality and need to make sure that the client gives to the new representative all of the information that the client thinks has been given to the IRS, so that the representative now, I'm thinking clinician, can decide, okay, is there something here that we failed to give to appeals that we want taken into consideration now, and what's the remedy? Maybe we can just persuade counsel in the litigation to make a concession on the basis of this. Maybe we need to try to get a remand in order to get this information before appeals. It's a pretty sympathetic request for a remand that says, I want to give to appeals not some fanciful information that I hope to develop in the future, but rather information that my client already gave to the IRS. That's a pretty good remand request there. Anyway, I just wanted to stress that the taxpayer may be quite unclear about this distinction between appeals and any other office in the IRS.
And I do run into that problem all the time where a petitioner in one of my cases will say, oh, well, why don't you have this and this and this that they have previously sent to the IRS? And I have to tell them, I'm so sorry, I don't have access to that. I don't have it. I wish that I could just log into my computer and see everything that they've ever sent to the IRS and that the IRS has ever sent to them and see all their past returns. And it's just not quite that simple. So I did just want to point that out as well. And another topic that we wanted to bring up was the cutoff. So when is the end of the administrative record? When is the cutoff? And arguably, you might say the cutoff is the issuance of the notice of determination in a CDP case. And I think it's pretty clear we would all agree that anything submitted after the notice of determination has been sent out is not part of the administrative record. But in my personal opinion, I think technically the cutoff might end up being a reasonable deadline that the appeals officer gave to the taxpayer for submitting additional information, even if that's before the notice of determination. As an example, say the appeals officer gave the taxpayer 30 days to provide additional documentation. The 30 days has passed. The appeals officer has written up the notice of determination and is waiting for the manager to approve it. And what if the taxpayer sends in documentation at that point? The appeals officer's already made their determination and moved on to other cases. There's actually a case that's on point with this. It's called Emery v. Commissioner. It's TC Memo 2018-55. And there the court said that documents submitted to the appeals officer after the notice of determination was drafted and approved, but 11 days before it was issued, should have been considered by appeals, and that those documents were part of the administrative record. So at some point there has to be a cutoff. In my opinion, I don't think the issuance of the notice of deficiency should be the last cutoff. I think it has to be sometime before that, but I don't know. Is it, in that case, it was 11 days. What if it had been sent in 10 days? What if it had been sent in the day before it was issued? So I'd love to hear from the other panelists about your comments and your thoughts on that.
I'll chime in on that. I doubt that there is an 11-day rule. Like you, I think that's not likely. And like you, I think that the question is, as you stated it at the beginning of your comment, a reasonable cutoff. And of course, whether a cutoff is reasonable or whether instead it's an abuse of discretion would depend on all the relevant facts and circumstances. For example, we would distinguish between two cases, in one of which appeals had followed a very brisk, demanding schedule, and another in which lots of time had been granted to the taxpayer to submit things. Multiple requests had been made, and finally a last attempt is made and a deadline is announced. If the activity that preceded the proposed cutoff showed appeals being patient and showed the taxpayer being dismissive and uncooperative, that's just going to be a different case. It would seem from our experience that appeals is often willing to let substantial time go by in the development of a case. One just can't help noticing that. And so in any particular instance where all of a sudden, again, from my point of view, all of a sudden, there's a remarkably brisk schedule proposed and insisted on, that comes with a question mark to me. I'll also say this, I think that the issuance of the notice of deficiency is, that's a very reasonable suggestion of a final deadline. Maybe that depends too on just how foreshortened the prior hearing process was. But assuming that in the overwhelming majority of cases that will be a reasonable cutoff, suppose you're the practitioner and the taxpayer comes to you with this bad letter he got yesterday and a sheaf of materials that he wanted to submit. What should you do? Well, I think probably most people would say, give it a try, send it in there. Probably they're not going to do anything about it, but wouldn't you rather be before the tax court saying, here's this stuff I wish that they'd considered, can we fix this? That's just a better position to be in than simply to be arguing to the tax court that you wish the court would take account of information that hasn't even been really specified yet. Anyway, that's my response. Is more just to your question about.
Oh, thank you, and I agree. I would say if you're past the deadline and you do finally get to mail in the documents, definitely still do it. And if that were my case, and I would say, well, send me what you sent in to the appeals officer, even if it was after the notice of determination, just send it to me so I can see what it is. And if to me it looks really clear that might have changed the outcome, then I'm a lot more likely to possibly try to do a remand or resolve it administratively some other way. So I think that's good advice as well. The next slide we wanted to talk about is we wanted to make sure that we pointed this out, this GMLE case. This is a big reason why you need to make sure that you're building the record that you need. And it's really important that you raise every issue to the appeals officer during the CDP hearing, because at a CDP trial, a taxpayer may only raise the issues that the taxpayer properly raised during the CDP hearing. And that's from this GMLE case that we have cited here. So if a taxpayer hasn't raised an issue during the CDP hearing, then the court will not rule on that issue at all. And it really just makes sense, because if a taxpayer didn't raise an issue during a CDP hearing and the appeals officer never considered it, there's no basis for the tax court to be able to even decide whether the appeals officer abused their discretion on that issue. And there really can be no abuse of discretion when an issue was never even raised or considered. So I think it is a logical rule.
And that is, and here's an instance where it really doesn't matter whether you're in a record rule jurisdiction or a non-record rule jurisdiction. In either context, you need to be sure to submit, to raise every issue that you hope to get court review on.
Right. And Jack, do you have anything to add here?
Simply to reemphasize, just to clarify a couple of points, this importance of raising issues on the record, as Judge Gustafson was saying earlier, this is not purely a record rule issue. This goes much beyond to the fundamental nature of what is it that the court is called on to do in a collection due process situation. The other thing I want to reemphasize, speaking as the director of a low-income taxpayer clinic, is yes, if you're representing a taxpayer, make sure everything gets before the Office of Appeals. I want to develop this issue, that first issue that I just brought up, a little bit more. And that's where we've talked a lot about the record rules so far. What happened and about what needs to be done to develop the record. So if there is a problem with the record, what can be done to repair that? If especially coming in as a representative for the first time. If, for instance, you've got a record that is one-sided or sparse, can the taxpayer obtain a remand to develop it further? The clearest answer that can be given is possibly yes. We gave you a list of cases here where this did happen. And I think that the takeaways here are twofold. If you go through and look at the facts in these cases and the reasoning behind them, the notion here is something that Judge Gustafson brought up earlier. In all of these cases, this is a fact-intensive inquiry, but in all of these cases, the unifying thing is that a remand might be appropriate, where the record is insufficient for the court to determine whether an abuse of discretion occurred or did not occur, where the record is either so lacking or otherwise so defective that the court simply cannot decide the issue. And as I was saying, this goes back to the fundamental nature of collection due process relief and indeed review of administrative agency decisions under the APA, which, as we said, is akin to CDP. The court's job is not to make a determination of what collection relief is appropriate. The court's job is to determine, did the administrative agency, the service, do everything correctly procedurally in making its review, and did it exercise the discretion granted to it in an appropriate way?
Mr. Snyder, I wonder if I could interrupt you to
Yeah.
tell a story that maybe points up the question. I think that the story I'm about to tell involves an easy case, but it wasn't easy to me as it was happening. I was kind of flummoxed by it. In this case, the taxpayer had requested a CDP hearing and then had largely failed to cooperate. But then when an adverse notice of determination was issued, the taxpayer duly filed a petition with the tax court and then largely failed to cooperate. And so the record in both the CDP hearing itself and in the litigation was very thin at the time the case was going to trial. So I had a telephone conference between the IRS attorney and the taxpayer, whom we were finally able to reach. And there was something unusual about the taxpayer. I thought she certainly was wanting to dispute what the IRS had done, but I thought I really was having trouble understanding her. And so I just decided that I would call the case at the calendar call and not decide yet probably the motion for summary judgment that the IRS had submitted. And when the petitioner appeared before me at the calendar call, it was fortunate that she had with her brother. And I finally realized I am not a psychologist, or I don't have any competence particularly about mental issues, but I could see that the petitioner was mentally challenged, but in a way that didn't prevent her from engaging in superficial conversation. Also, it became clear she was unable to read or write, but was reluctant ever to admit to anyone that she could not read or write. And it turned out that her request for a CDP hearing and her petition had been drafted by her helpful brother, who was there with her at the hearing, and who explained that he did his best to try to help his sister, but he did not live with her, and so he would come to her house and try to handle her mail, but it wasn't always there. And so, yes, she had probably failed to answer these letters that had come in. To me, at that time, early in my handling of CDP cases, I found it hard because if I asked the question whether appeals had abused its discretion, I couldn't fault anyone for the handling of the case. They had dealt in writing, as they must, and they had sent out multiple letters and just had not gotten any answers, so they did what they had to do. So on the one hand, again, there was no faulting appeals for the handling of the case, but it was quite clear to me that because of this individual's unique circumstance, she had not gotten a hearing. She was not capable of participating in it. And happily, the brother was willing to have a power of attorney signed by his sister in favor of his communicating with the IRS, and he was willing to serve as next friend of the petitioner. Under our rule, a person who's not able to represent themselves can sometimes be represented by a non-attorney next friend. And so he was willing to do that, and the respondent didn't object to a remand of the case. I think they perceived that the process was well served. Now they had a literate, responsive individual they could deal with, and so not surprisingly, in fact, the case was settled, and I never had to decide any more about it. I bring up that as an instance that, to me, shows this proposition that even if you can't exactly fault the agency for any abuse of discretion, if you can say that the hearing simply failed to give the in this case taxpayer an opportunity for the hearing that the statute entitles them, then it is appropriate to remand. The record is not adequate. Again, through no fault of appeals, the record is not adequate. Review of the situation is really not possible, and so we need another remedy, in this case, remand and supplementation of the record.
Thank you, Judge. Elizabeth, how do you challenge the record when it doesn't include something that you think it should have included?
Sure. Well, as we have already discussed, it's a good idea to keep copies of everything you send to the appeals officer during the hearing, and it's a good idea to memorialize your conversations with the appeals officer in writing, and that way you know what you've submitted and you know what documents should be in the record. And once a case is docketed, you can ask the IRS attorney for a copy of the administrative record and make sure that all your documents are included. So that's an easy way if it's already docketed. And that will cover you for documents that you think should be in the record but are not. But to further answer your question, I'd like to discuss some recent whistleblower cases because they deal with supplementing the administrative record. Whistleblower cases are a good analogy to CDP because they deal with abuse of discretion. There's an administrative record. It is pretty similar. So in fact, when I work at a whistleblower case, it's a pretty similar process where I also compile the administrative record and then write my motion for summary judgment that there was no abuse of discretion. So I'll just go to the next slide here. I wanted to talk about this Casper case. There's two whistleblower opinions that are interesting on this point, but the first came out in 2018 called Casper. Casper is the case that limited the scope of review in whistleblower cases to the administrative record, but the case did name 6 exceptions where the record could be supplemented, and that's where the agency action is not adequately explained in the record, when the agency failed to consider relevant factors, when the agency considered evidence which it failed to include in the record, when a case is so complex that the court needs more evidence to understand the issues, where there's evidence that arose after the agency action showing whether the decision is correct or not, and 6 is where the agency's failure to take action is under review. Next is Van Bemmelen, which came out in 2020. This expands on Casper, and it also deals with supplementation of the administrative record. In Van Bemmelen, the tax court described 2 scenarios that arise in disputes about the administrative record in whistleblower cases. And the first is where the petitioner is arguing that the agency considered the document but failed to include it in the administrative record. In order to overcome the presumption that respondent or the IRS has properly designated the administrative record, petitioner has to make a substantial showing made with clear evidence to the contrary. So I think that presumption that the IRS has properly designated the administrative record is important and could be considered in a CDP context. The second scenario is where the petitioner argues that the agency did not consider the document but should have. In that scenario, the administrative record can only be supplemented if the agency deliberately or negligently excluded documents that may have been adverse to its decision, if background information was needed to determine whether the agency considered all the relevant factors, or if the agency failed to explain administrative action so as to frustrate judicial review. So again, I think that these two whistleblower cases could have application to CDP cases. They're certainly analogous situations. And in Van Bemmelen, I think it's important to distinguish between these two types of supplementation. Is it a situation where the administrative record doesn't contain something where the appeals officer did consider, or is it a situation where the administrative record doesn't contain something that petitioner thinks or wishes that the appeals officer should have considered but did not? I also wanted to point out that even the Eighth Circuit in Robinette envisioned that there may be a time to supplement the administrative record in a CDP case, such as where the record does not adequately describe the basis for the determination. And of course, if there is a really big dispute about what is in the administrative record in a CDP case, if it were my own case, I would probably think really hard about whether it would be easier to file a motion to remand the case to have the appeals officer consider that disputed document and avoid this issue. And Judge Gustafson, I'd love to get your thoughts on this.
Okay, so let's make up an example. If we suppose that a CDP petitioner is arguing, here, in the record that they're giving you, Judge, they show you that I submitted 10 exhibits, 1 through 10. I submitted 18. Here's 11 through 18. I don't know what they're talking about. I'd like you to receive exhibits 11 through 18 into the record of this case. And if we suppose that the record rule applies, then this question is put to us. And I think that you're consulting Van Bemmelen and Casper to answer the question. It's entirely reasonable. Maybe that's the right thing to do. I will just note two things. Number one, those are, of course, whistleblower cases, and we haven't yet seen the tax court apply that reasoning per se in CDP cases. Maybe it's natural to assume that the tax court will, but I think it hasn't happened yet. Second thing to consider is that Van Bemmelen is a DC Circuit case, and all whistleblower cases will end up being appealable to the DC Circuit, I think, but not all CDP cases are. So someone working on this question, if it's likely to be appealed to another circuit, will want to know more than I know about what other circuits might say in answer to this question. But I think the matrix you present is entirely reasonable. And I'd say, yes, theoretically, you now, in the CDP case, where you're considering exhibits 11 through 18, proffered now by the petitioner, the theoretical remedy, I think, is to have a hearing at which you decide the question whether those things properly belong in the administrative record. And I think you're right that in making that decision, you entertain the presumption of regularity in favor of the accuracy of the proffered record. And so you're looking to the taxpayer to overcome that presumption and to prove on some kind of an elevated standard that he really had submitted exhibits 11 through 18. As you maybe are implying, I doubt we're ever going to hold that trial, because I think that when someone comes forward with some specific thing, with anything like a credible or sincere insistence that they were submitted, I see Chief Counsel saying, well, let's just remand it and let appeals look at them, and probably the case goes away in that fashion. You can tell me if I'm not responsive to your question, but that's how I see it.
Well, thank you so much. Yeah, it's very interesting to think about these analogies that are somewhat similar to CDP, but not quite. And while we're on that topic, I'll go to the next slide here. We just wanted to bring up, while we're on the topic of the record rule, that the Taxpayer First Act added a new subsection to 6015, which is the innocent spouse provision, and that's E7. It provides for a de novo standard of review of innocent spouse determinations based on the administrative record and newly discovered or previously unavailable evidence. This does add a new requirement for IRS counsel that we now must identify and submit the administrative record to the tax court in an innocent spouse case. So prior to the enactment of the Taxpayer First Act in 2019, denial of relief under Section 6015 was still reviewed by the tax court de novo, and the court was not bound by the administrative record. So in practice, does this really change anything about how an actual innocent spouse trial would go? Because I think it may make the stipulation process clearer, but other than that, I'm not really sure how much this changes anything, since the standard of review is still de novo in innocent spouse cases, and the court can still consider evidence beyond the administrative record. But I'd love to hear from my fellow panelists on their opinion about this change, and then whether there are any CDP implications. So Jack, do you have any thoughts?
I tend to, having of course not seen one of these in litigation yet, I tend to agree with your take on this. The record here is defined extremely inclusively, and I doubt there's much significant CDP result here. There may be deeper issues for innocent spouse, but I'm not sure there are any CDP specific implications.
Thank you. Judge Gustafson, do you have any thoughts about that? You had something to say about the intervener.
I too am going to, pardon me?
Oh, I think you had
something
to say about the
last thing you said. Oh, yeah. I too am going to pass on addressing the innocent spouse question per se, and simply observe two things that maybe assist in comparing that jurisprudence to the CDP case. The first is that the innocent spouse situation involves the possibility of an intervener to contradict the factual presentation of the innocent spouse, and I don't know how that will play out under new subsection E7. I don't suppose the intervener is confined to the record. Maybe anything the intervener presents is considered additional newly discovered or previously unavailable evidence. I'm not sure. But in any event, the newly discovered or previously unavailable evidence exception to this new innocent spouse regime maybe brings us back into the fold of the APA, which allows supplementation of the record whenever it's inadequate under the principles that you extracted from Casper and Van Bemmelen. And so I'm supposing that these things end up being broadly equivalent, and so I don't observe any real game-changing light from this innocent spouse jurisdiction on the CDP context.
Thank you. And next, we'll talk about remand. And we've alluded to this a few times, that the effect of winning a CDP case is that it's remanded. And I do find that petitioners in CDP cases also often feel very frustrated when they realize that the tax court can't go tell the IRS to give them their installment agreement that they want. And I'd like to hear from Judge Gustafson and Jack Snyder about their thoughts on that issue and how that ties into the administrative file. I know personally I try to educate the taxpayers in my cases, and without giving them legal advice, I do let them know they have the option of filing a motion to dismiss and then working with collections to try to get the result that they want. And I just try to help them understand their different options, because I like to say, well, what is your goal from this case? And it's usually not just to get a remand. So I'd love to hear your thoughts.
That's my experience also. I think it's very counterintuitive, in fact, to the typical taxpayer to be told that if he or she wins that case before the tax court, the prize is they get to go back before appeals. It's not literally necessarily true, but it's practically true, with only rare exception. And pardon me if I'm essentially repeating what you said, but the take a lien case, for example, where the IRS has filed notice of lien, and the taxpayer believes that the agency mishandled it, shouldn't have done it. The fact is that that one of the remedies that they can get if they win the case is that the tax court will blow up the lien. They didn't follow the rules in filing it, wasn't justified, so I'll blow up the lien. But I always have to warn the taxpayer that this doesn't disable the IRS from later refiling. That liability still exists there, and so the consequence of this may be simply that the IRS refiles their notice of lien, this time fixing whatever flaws they had before, and putting you right back in the same position, except not really the same position, because what the statute says is that you, the taxpayer, are entitled only to one instance of judicial review of this lien, a lien on this liability. So if the IRS does this again, then the next time they come around, you won't be able to file a tax court case. Is that what you want? Now, I have had, I think, one taxpayer say to me, yes, that is what I want. I get it, I understand, but I want you to blow up this lien. But normally, what I get instead is taxpayers who are, maybe they're disbelieving of what I'm telling them. They think it's very unfair, but typically they do want the remand anyway, because they would rather have their dealings with appeals be subject to being brought before me again than get no judicial review at all. So mostly they are accepting of that, but it's very hard because as I say, the taxpayers' confusion or whatever is quite understandable. Anyway, never said enough.
It's a frustrating issue for taxpayers in my experience as well. Even but Judge Gustafson's point about one hearing per period is very well taken. But even going beyond that, most of these taxpayers who get to the point of judicial review in CDP have been dealing with the service in one form or another for an extended period of time and are very frustrated to have to, from their point of view, go back and do it all over again. In much of the CDP litigation that I've seen since directing a clinic, the taxpayers have ended up taking a voluntary dismissal of the case and then simply going back and working with the collection division, of course, in clinic cases now represented, and hopefully getting a better result that way. But I do want to mention something about remand itself, and that is remand has, for all the reasons we've talked about, kind of a bad rap. When is remand worthwhile? I'm doing air quotes as I say that, from the point of view of a taxpayer. Remember that, as several of the other panelists have said, that most collection due process cases in the tax court are decided on the papers, essentially on briefs, usually with motion for summary judgment by the service, and if the taxpayer is represented, maybe even a cross motion by the taxpayer. Oftentimes, however, as you've heard Elizabeth say a number of times, counsel will recognize that there was some defect in the administrative process. So when is a remand valuable to the taxpayer? It's probably most valuable when it's mutually agreed between the parties in tax court that remand is appropriate. That is, that there was some defect in the process below, such as evidence that didn't make it into the record, for example, as we've been talking about today. But not just that. That's not going to do much good to the taxpayer if the new evidence doesn't change the outcome. It also needs to, ideally for the taxpayer, would be something where the unconsidered matter or unconsidered argument or unconsidered fact also is outcome changing, and probably most effective when that's agreed by counsel, because that's something that counsel can note in history that appeals may see when the case wends its way back to appeals. So remand is not completely useless, but remand has got to be the right case. And I certainly, having tried to explain remand to taxpayers a number of times, do not envy the tax court judges having to do it from the bench. That's all I have.
Thanks, Jack. We're going to hop over the last slide, which is just our objectives part, and get to a few questions that came in that I think are pretty good questions. Several people asked about the record rule circuits. That's the 1st, 8th, and 9th circuits. And the citation that Elizabeth spoke about, that was Emery v. Commissioner. And that's Tax Court Memo 2018-55. And a couple questions came in that I'd like to pose to the panel kind of generally. They've asked about recording the appeals conference. So there is an ability to record the appeals conference. How does that get into the record, or does that automatically become part of the record?
Yes, at least in my experience, it would definitely be part of the record. In my experience, I've only seen it, I think, one time. It's just not done very often, but maybe Jack or Judge Gustafson, maybe you all have seen it more. But
my experience in terms of its making its way into the record is similar to yours. I think the fact that recording rarely happens is due to the fact that the rules on recording of collection due process hearings and the like are fairly old in CDP terms. They come from the first few years of the statute, when a majority numbers-wise of the cases that the service was seeing were generated by tax protesters. And there the goal was to streamline the process and minimize the number of frivolous hearings that were being requested and minimize the time spent on them. And because of that, appeals developed this aversion to having, quite apart from whatever the rules say, to having the hearings recorded. So it's something that's just fallen out of the culture of practice, both among practitioners and the service, quite apart from whatever the rules say on it.
Judge Gustafson, have you seen recordings?
No, I have nothing to add. I have no experience in that.
Oh, okay. Well, then let's get the next question. Is, can the taxpayer request the admin file before tax court or after tax court filing?
Well, this is Jack Snyder. The taxpayer can request the administrative file at any time through the IRS Office of Disclosure by submitting a Freedom of Information Act request. There are letters, sample letters to do so, strewn all over the internet, and it's something that the Disclosure Office understands very well. If a case has been docketed, it may be possible for counsel to get its hands on the file, but having worked for the government, I can tell you that getting one's hands on administrative files, even at the government, is a slow and frustrating process. So can the taxpayer get it? Yes, definitely. The issue is getting it in a timely fashion. And that's not just an issue for taxpayers, it can be an issue for the service as well.
I did want to say there's a new change required by the Taxpayer First Act, which says that a taxpayer must be given access to non-privileged portions of the case file prior to their appeals meeting. So you can ask from the appeals officer, you can get your admin file from there. And then the benefit of that over FOIA is you don't have to pay the fee for FOIA.
Or hopefully wait the time.
But if a case is docketed, I would recommend not asking for a FOIA request, because then the FOIA people if it's my case, the FOIA people just come ask me when you could have just asked me directly. So hope that made sense.
If there is a point of contact at the IRS other than the disclosure office, that point of contact should be the person to ask for a copy of the admin file. If there is not, then unfortunately you're reduced to the slow and occasionally expensive FOIA process.
And a follow-up to that, which I don't think happens, but will a FOIA request slow down the CDP process?
It could, it could. Go ahead, Jack.
It could because of potentially the file needing to make its way from one part of the service to another. Again, that's why the summary that I tried to make of what Lizzie was saying is, if you have a point of contact at the service, an appeals officer, a counsel attorney, whoever, ask for the administrative file from that person. If there is no point of contact, say notice of determination has been issued and the case has not been assigned in counsel, that may be the situation you're reduced to FOIA. But there is only one admin file, and it cannot be in more than one place at once. So sometimes the service has trouble tracking them down or just moves slowly on it.
All right. Well, unfortunately, I think that is our time. 1, 2, 3. That's all the time we have. Before we leave, I ask all attendees who want CLE credit to stay connected for instructions to get CLE certificate. Also, please wait for the evaluation to come up on your screen. If you would like to learn more about this topic, the third and final webinar in the Just the Facts series will be held on April 27th. The registration is free. Please check the tax section website for more information. To our faculty for this program, thank you so much for sharing your expertise with us. On behalf of the ABA, I'm Matthew James. Thank you all for joining us. I will now turn it over to the operator for some additional information.
Thank you. On behalf of the American Bar Association and the ABA section of taxation, thanks so much for participating in this program. To learn more about the sponsors, visit the ABA website, which is americanbar.org. Thanks so much, and please do click on the evaluation link, as we value your feedback.